Buzz Thompson clerked for Chief Justice Rehnquist and has served as a special master in the Supreme Court water adjudication, Montana v. Wyoming. He's now on the law faculty at Stanford and by any standard is one of the premier scholars in natural resources law. Buzz is the kind of person who goes out of his way to be a full colleague with other professors in the field, and my sense is that in particular the young upcoming professors appreciate that a whole lot. Buzz?
So it's great to be here, and I want to thank the University of Colorado for putting on this particular conference on the occasion of the 50th anniversary of the Arizona versus California decision. I must admit I was a little bit puzzled at first as to why I was invited to actually present, because I actually don't do a lot of work on the Arizona versus California decision or on the Colorado River case. I've ultimately decided it was because you needed more people from California here. If you actually look at the speakers of this particular event, there are 3 representatives of Arizona who are here, versus only 2 from California who are speaking, me and Jeff Keitlinger. There are an equal number 2 from Nevada, even though they only get 300,000 acre feet. And so you would expect, just in terms of the allocation of the water in the Arizona versus California case, we should have more representatives than Arizona. But what I am really sort of the third in a trio of speakers who are looking at the broader issues involved in the Arizona versus California decision. Obviously, Arizona versus California is of incredible importance to the Basin states for the Colorado River. But at the time it came out, it actually attracted a number of major law review articles who claimed that Arizona versus California was one of the major water decisions ever to be handed down by the United States Supreme Court. And if you look at the broader implications of Arizona versus California, I actually think that that might be totally wrong. In the long run, it might be that Arizona versus California goes down as a decision that's very important for the Colorado River, but of not much precedential value in any other way. It really addresses 3 more general issues. The first is the existence of Federal Reserve water rights other than Indian water rights. And that clearly is going to have some continued importance, but I think particularly after the United States versus New Mexico decision of far less importance than the justices actually probably contemplated at the time that Arizona versus California was handed down. The second was quantification of Indian reserved water rights through the PIA standard, and it's still open to question as to how long the PIA standard will actually survive in the United States Supreme Court. And then the third issue, and it's the one that I want to focus on, is how we should go about actually allocating the water of our interstate rivers. Because Arizona versus California suggested really for the first time that there was a third rail, and I mean that in every single possible uses of that term rail. But the third rail was that you could allocate water by going to the United States Supreme Court and getting a judicial apportionment. You could actually negotiate with your fellow states and come up with a compact, or according to the Supreme Court in Arizona versus California, you could go to Congress and get an allocation from Congress. Now, this is only necessary. We only have to worry about this issue of interstate allocation because of the stupid way in which we have actually drawn state lines in the United States. So if you look at this particular map, what you will see is that most of the time we totally ignored interstate rivers, right? And we drew, particularly in the western United States, these straight lines. Those of us who were involved in various Western issues, I mean, only the West had the hubris to actually decide that we could ignore all natural landscapes and just draw straight lines across it. But those straight lines frequently cross interstate rivers. And to the degree that we pay attention to interstate rivers, what do? We use them as borders between states. So we have basically ensured that we're going to have interstate disputes in the United States. 95% of the fresh water which is used in the United States comes from one or another interstate river system. So how we actually go about allocating the water of those rivers is an important question. Now, even though we came up with these particular borders, again, there were other alternatives that we passed by over the years. And the story, of course, has to begin with John Wesley Powell and his report on the arid states of the West, because Powell, looking at the way in which the West was developed, suggested to Congress and the United States that the primary mechanism for actually organizing water issues in the Western United States should be by watershed. And this, in the upper left-hand corner, shows the map that John Wesley Powell proposed for, again, allocating water in the Western United States. The West would be really run primarily by watershed districts or irrigation districts that would have as their borders the borders of the watersheds of the major interstate rivers. But unfortunately, Congress paid no attention to Powell when he initially made this particular proposal, nor did it pay any attention to people who, after Powell, continued to push for one of two different options. Either the option that Powell saw, which was that we should organize the West largely across watersheds, or on the notion that rather than having a system where states are the ones that actually manage the waters of interstate rivers, why don't we basically nationalize the interstate rivers? Why don't we say that all of the unappropriated rivers of our interstate rivers belong to the federal government and that it is Congress's responsibility to actually allocate and manage those waters? So after John Wesley Powell in the late 1880s, there was significant interest in promoting irrigation in the Western United States by taxing the federal lands and using that money to build irrigation programs in the West. And proposals, particularly in the late 1880s and early 1890s, suggested that as part of a federal law that would provide for incentives for Western irrigation systems, that Congress should assert its authority, declare that actually Congress, again, has authority over all unappropriated interstate waters in the West, and that those interstate waters should be managed by irrigation districts largely along the lines that Powell had set out. And the members of Congress who pushed this particular idea feared the states. They believed that the states did not really have the capability of managing interstate rivers, and there was particularly a concern that the states would favor the cattle interests as against the irrigation interests. William Vilas, who was a Secretary of Interior in the late 1890s from Wyoming, was one of the people who particularly pushed this idea. But he ultimately lost to Joseph Carey in the Carey Act, which was passed in the late 1800s. And as you all know who've looked at the Carey Act, what the basic bottom line there was that it was private enterprise that would build the irrigation systems, and they would build it subject to state jurisdiction over the western waters. Now, to the degree that you have state control over the western waters, then the question has to become, well, how are you actually going to allocate those interstate waters? And the first approach that was taken was to go to the United States Supreme Court, the only place where states can go to sue each other, and seek a judicial apportionment of that water. And this was what happened in the case of Kansas versus Colorado in the early 1900s. The federal government at the time of Kansas versus Colorado had actually not given up on the idea of federal control over interstate waters. And in fact, in this first interstate adjudication case before the United States Supreme Court, the United States Attorney General took the position that Congress had authority to regulate all interstate waters under the Commerce Clause, and that furthermore, Congress had used that authority in a series of acts to impose the prior appropriation system on all users of interstate water. So if the United States position had prevailed in Kansas versus Colorado, we would basically have the prior appropriation system controlling all interstate river systems without any attention to borders. But the United States Supreme Court in the Kansas versus Colorado case instead turned to this concept of judicial apportionment, that the waters actually belong to the states, and that what the United States Supreme Court's role was to actually allocate that water between the states so that they could assert their jurisdiction. The Attorney General of the United States at the time of Kansas versus Colorado saw this as a significant defeat for the United States interests. And in his report to Congress in that particular year, said that the Supreme Court in this particular case had rejected the position of the United States on the ground that Congress had no power to control the flow of waters in the western United States, except in a matter necessary and affecting the navigation of the streams. So the United States at this particular point takes the Kansas versus Colorado decision as basically saying that the federal government has no role in the allocation of these western waters except to the degree that it's necessary in actually to promote navigation. So for the next 10 years, the principal mechanism that everyone believes is to be used in order to allocate the water of interstate rivers is to go to the United States Supreme Court and obtain an interstate apportionment. That changed with the Colorado River Compact, the first of the interstate river compacts, and it's really the responsibility of that guy right there, Delph Carpenter, a Coloradan, who was probably a little bit upset that actually the first 3 interstate allocation cases filed in the Supreme Court are actually filed against Colorado, and rails against the facts that the states in the West are, in his words, rushing into war by going to the United States Supreme Court, rather than, in his term, turning to friendly settlement through diplomatic channels. And so he pushes the idea at this point that rather than going to the United States Supreme Court, what states should be doing during this particular point in time is instead entering into agreements amongst each other, settling their dispute through compacts. And he saw there were a variety of advantages to compacts. First of all, if you actually were able to agree to an allocation of the water, then you could go and get a federal project, but he thought it would be very difficult to get federal projects without those. And furthermore, the United States government was still claiming, even at this period of time, that they had control over the water in the West. And his view was the more of these compacts that you actually got out there, the more that would actually defeat the federal government's claims. So over the next 40-year period of time, you end up with 17 compacts being negotiated in the western United States. For those of you from Colorado, I thought you would find it interesting that if you look at the first half of those compacts, all but one of them involved Colorado. Colorado was really the state that proved the model for the workings of interstate compacts. So as late as 1963, at the time of the Arizona versus California decision, the view was that there were 2 ways of resolving interstate disputes: go to the United States Supreme Court or resolve these by compact. And that brings us to the Arizona versus California decision, where the United States Supreme Court decides, I think absolutely incorrectly, that Congress in the 1929 Boulder Canyon Project Act had actually allocated the water of the lower Colorado between Arizona, California, and Nevada. But evenly more interesting, never even stopped to ask whether or not Congress had that particular power. The report of the special master in Arizona versus California spent 2 sentences talking about the power of Congress at this particular point. Saying that it was obvious Congress had that power. The United States Supreme Court never even addresses that particular question. As I mentioned, the Arizona versus California decision attracted a number of major law review articles from the leading lights of water scholarship at that particular point in time, people like Charlie Myers and Frank Trelease and Ed Clyde. And all of them said two things. Number one, they were a little bit surprised that the United States Supreme Court had announced, without even talking about it, that Congress actually had the authority to do this. As Charlie Myers said, given Commerce Clause cases by this point in time, it probably was a no-brainer that, in fact, Congress had this particular authority. Although, as Charlie also pointed out, the fact that the Supreme Court had only discovered this power in the 174th year of the Republic suggested that maybe the claim was a little bit more difficult than the Supreme Court suggested. But these three leading lights in the water field also thought this was a brilliant idea, that rather than going the compact route or going to the Supreme Court, the idea of going to Congress for an apportionment made a lot of sense. Their arguments were, number one, this is a political decision. This is not really a decision that should be made in the United States Supreme Court. This is the type of decision that Congress should be making. Second of all, it would be a lot faster to go to Congress. Compacts at this point in time were taking 10 years on average to negotiate. They thought you could go to Congress and get a congressional apportionment fairly quickly. Furthermore, it would be cheaper. One of, I think it was Charlie Myers, who pointed out that the special master alone had charged $125,000 for his services in Arizona versus California. It actually doesn't sound like very much money anymore, but back then Simon Rifkin actually made out quite well to the costs of Arizona and California in particular. And third of all, they said Congress actually has the expertise and the procedural mechanism necessary to sort of investigate the issues and come up with a good apportionment of these interstate waters. I think Arizona versus California was too little and too late. By Arizona versus California, the states had staked their claims to the waters of the interstate rivers. And once the states staked those claims, saying that Congress had the authority to allocate the waters of the interstate rivers almost guaranteed that Congress would never do it, because the states would come in and object to probably virtually anything that Congress might imagine doing in any particular watershed. I think the Supreme Court lost its opportunity when it didn't declare at an earlier stage that actually interstate rivers are national rivers rather than belonging to the state. And I think we're still stuck with the implications of a state-dominated system. So what's happened since Arizona versus California? You would expect after these various law review articles that maybe Congress would have actually allocated the waters of a variety of interstate rivers. Well, at best, I can come up with maybe three situations where Congress has actually maybe allocated the waters of interstate rivers. The one situation where they clearly did it was in the case of the river systems that Eastern California and Nevada share. And these include Lake Tahoe, right here, the Truckee River, the Carson River, and the Walker River. And Congress did allocate the waters here in the Truckee-Carson Pyramid Lake Water Rights Settlement Act of 1990. But to understand why this isn't a particularly great precedent to turn to, we actually have to go back to when the dispute between California and Nevada really arose, which was in the early 1950s, at a time when there was a lot of growth taking place in the Lake Tahoe area along the lines of recreation and second homes. Nevada began to be concerned that California would start taking more water out of the Truckee River. And the Bureau of Reclamation was asserting claims to dormant water rights for various Nevada water users. Now, in the light of this, actually what Nevada and California did not do was to turn to Congress. The last thing they wanted to do was to have the federal government resolve this particular dispute. Instead, they decided to negotiate an interstate compact. And they got Congress's approval to negotiate an interstate compact in 1955. And at the start of their negotiations, they had extreme optimism. The Nevada state engineer, on the very first day of negotiations between California and Nevada, said, "I am sure that we have a group here that will come to agreement within a few months, a year or so at most." It took them 13 years. to reach an agreement in this particular case. And one of the things that we have found is over time, compacts are taking longer and longer to negotiate. Not only did it take them 13 years, but they only got there by narrowing the issues so that the only thing they actually resolved was the allocation of water that was not yet being used in these particular river systems. There was suggestions that they should actually deal with non-consumptive rights, for example, of the environment. Notion was that was too complex, and started talking about that, they would never reach an agreement. People suggested that they go back and revisit existing rights. California in particular thought Nevada's use of the water for irrigation was anachronistic. And again, they decided not to address that particular question. They thought about addressing issues of water quality, fish and recreation, groundwater, what happens if things change in the future. All of those were thrown out as discussions during the negotiations on the theory that they would never be able to reach agreement if they had to consider all of those. Furthermore, they only reached an agreement on the really rough issues, deferring to an interstate commission that they formed to actually resolve those particular issues. But they did reach an agreement in 1968. California signed off on the compact in 1970. Nevada in 1971, only to find the federal government balking and refusing to actually agree to the compact because the compact ignored the Paiute Indian Reservation in Pyramid Lake. And by this point in time, the federal government was beginning to actually pay attention to Indian water rights and also to an environmental interest. And so the federal government refused to agree to the compact, and it was only through federal negotiations and finally a congressional bill that we were able to get an apportionment here. So this is not an example where Congress rushed in to apportion the waters, but it does show the difficulties of resolving these issues by compact, because the federal government today has to be a party to these various issues. And furthermore, these issues are getting more and more complicated to actually resolve. Another potential example of congressional apportionment of the water is the Missouri River Basin. This is in some ways the closest that we come to the Colorado River Basin. They actually talk about the law of the river, except the law of the river in this particular case is the law set down by the Army Corps of Engineers in the form of their Master Water Control Manual. And there was actually an interstate dispute that South Dakota filed before the United States Supreme Court in 1985, in which South Dakota argued that Congress actually had allocated the waters of this particular river, but the Supreme Court actually declined to take that particular case. I actually think the federal government does control this particular river system, but it backed into it. It backed into it by building a variety of flood control and navigation projects that effectively ended up allocating it. And then the third example would be the Great Lakes. The Great Lakes, as Rob Glennon pointed out earlier today, has always been afraid that we would steal their water. So they entered into sort of an informal agreement in the 1960s that basically said, if you want to allocate water and take it out of this watershed area, then you have to consult with the other states. Michigan hated that. They thought that you should only be able to actually take water out of the watershed if you got agreement from every single state. And so what they did was they went to the federal government, and in the 1968 Water Resource and Development Act, signed by Ronald Reagan up there, Congress agreed that the only way in which you could allocate water outside of the watershed was by getting the agreement of all 8 of the states. Now, the federal government actually does, I think, get involved in water allocation in other ways. They nudge frequently the states to actually come to an agreement. The only way in which we actually got the Colorado River Compact was federal nudging by saying, if you want your Boulder Canyon project, then you have to have a compact. And I think if you looked at compacts in the United States, you would find that at least half of them were negotiated because the parties were told, you want federal money? Then you have to enter into a compact. So the federal government has nudged. Another interesting example of nudging are 2 interstate federal-state compacts, in which, in these particular cases, you had Alabama and Florida were concerned about the possibility that the Army Corps of Engineers would take a lot of money for Georgia, and particularly for the city of Atlanta. And so what they did was they went to Congress and got Congress to agree to a compact that would provide for a negotiated agreement of an apportionment of these two river systems. And this is the most interesting thing, that the federal government would be largely bound by that particular agreement. Now, what they had to agree to in return was that before the federal government would be bound, a federal commissioner who would serve on the commission to actually negotiate an apportionment of the two river systems would have to consent to it. And even though the states actually did come to an agreement, they were never able to get that federal consent. They were never able to come up with an agreement that actually satisfied the federal government, that it would satisfy things such as the Clean Water Act and the Endangered Species Act. Another way in which we've nudged the states is by trying to create various river basin commissions. This is President Kennedy signing the law that set up the Delaware River Basin. Another very interesting idea, let's bring all the states together. These also have never really worked that effectively, largely because the federal government has had a difficult time speaking with one voice in these various negotiations, and it is virtually impossible today to come up with an interstate agreement for allocating waters without being able to bring in all of the various federal agencies. In addition to nudging, we also engage in indirect allocation. We do this by building various federal projects that actually do allocate the waters of interstate rivers. We also do this through laws such as the Endangered Species Act or the Clean Water Act, which put limitations on exactly how much water each individual state can take. Now, so Congress effectively hasn't responded to the opportunity that Arizona versus California provided. And in the meantime, the other approaches have atrophied. This shows compacts that have been negotiated over 20-year periods of time, starting in 1921. And what's interesting is the peak of compact negotiations was the 1941-1960 period. You'll see that new negotiations, these blue lines, actually go down after that. In fact, after Arizona versus California, only one new, totally new compact has been negotiated. And in many ways, I think Arizona versus California killed them off by suggesting that there was this third rail and by refusing to actually address how we can make interstate apportionment readily available. So let me just really quickly, because I'm running out of time, suggest that actually I think Congress's role is even more important than it was in the past. I think all the reasons why congressional involvement was important in the past is still true. Plus, in addition to that, congressional involvement is more important today because waters are even scarcer, so it's urgent that we actually address some of these issues. There are more issues that are very complicated for either the courts or negotiators and compacts to address. Federal involvement is inescapable, so that makes it very difficult to resolve interstate disputes without the federal government's involvement. And water is going to be less stable over time. So we not only have to resolve things in the past, which is what compacts and judicial apportionments have historically done, and start thinking about what are we going to be doing in the future. Now, the problem with all this is politics. This is actually a picture of the California legislature earlier this year. But I put this up here because the problem with all this is it's one thing to rail against the current state of events. It's something else to come up with some new ideas that actually are going to be politically acceptable. But let me just brainstorm for a second. And I want to throw out just 3 really quick models of new directions that we might head. And I'm going to start out with the most incremental. So the most incremental is to maybe have the federal government play the role of an empowering river coach, right? In California, everyone's adopting life coaches, right? Maybe what the states need are river coaches, okay? River coaches who can provide encouragement, sort of push you to a interstate agreement, provide you with the expertise necessary. And in some ways, I think the Department of the Interior is already doing that through its WaterSmart program. But what I would suggest is if we really want an empowering river coach, that what we want is the WaterSmart program with a couple of other things. We want advanced federal approval for if the states come into an agreement, then Congress will approve that as a compact. Second of all, we need the ability to resolve related federal issues and bind federal agencies. And I know the federal government would never agree to this, but unless the federal government is willing to come in and actively negotiate under the Endangered Species Act and the Clean Water Act, then I think we're ultimately doomed to failure. And as part of that, maybe what you have, if the states as part of this come together and agree on something, is the federal government delegates authority under the Clean Water Act and the Endangered Species Act under that compact to the states. So that's my empowering river coach model. My second model would be an interstate water adjudication board. One of the problems right now is water adjudications are just too complicated and too expensive and too time consuming. So could Congress create a water adjudication board that would be easier and would address more comprehensively interstate water apportionments? It would be an expert board. States could voluntarily go to that rather than the United States Supreme Court. Or you might even have the board be able to independently take on an interstate allocation. And just so long as I'm dreaming, this is brainstorming, and I want your ideas at the end of this, is what about the idea of giving the board power over water bankruptcies so that if a state compact is no longer working because maybe it's allocated too much water, more water than it's actually entitled to, you could go to this particular board in a form of bankruptcy and get the board to actually reform the mechanism to live within your resources. And then my third, my favorite, this is for those of you who are economists out there, is what about actually setting up a series of independent river operators? Those of you who work in the energy field are aware of the idea of independent service operators. Frequently, these ISOs work on a multi-state basis, and basically what they're responsible for is allocating energy across a particular region, making sure all needs are met in the most economically efficient fashion. So maybe what we need are independent river operators who actually operate each of the interstate river systems, starting out with the existing entitlements and then building into them interstate markets so that you end up with water actually being managed in an efficient and effective fashion, unlike what we do today. So those are just three models. Some of you know that I actually led a group of my students to the Colorado River for a 2-week rafting trip 2 years ago. This is a picture from up on one of the hillsides looking down at the river. And I just want to leave this here and just ask you all to be thinking about the question of none of the systems we've come up so far work particularly effectively. So if you don't like any of my three models, what would be your model? How can we approach this issue of interstate allocation better than we've done in the past? So thank you very much.
Thank you, Buzz. Bob Johnson, now water consultant with Water Strategies, grew up in rural Nevada and has never lost his love for the Southwest. He's a true citizen of the Southwest and has almost the perfect background for a future commissioner of the Bureau of Reclamation. His title for his talk today is the Secretary of Interior as Watermaster, Decision Making in the Colorado River Watershed. In 2006, he was appointed Commissioner of the Bureau of Rec, and because the Secretary, who is the Watermaster, must necessarily delegate a lot of the Secretary's responsibility, Bob was very much the Watermaster of Colorado River to the extent that a person can really be that. and has been much respected for his work in that position, and a lot of affection also from your public. So thank you for coming, Bob, and we'll look forward to your remarks.
Thanks for that nice introduction. I spent, as you all know, a lot of my presentation here. You all lived through this with me, so you're probably not going to hear anything that you didn't know. Some of you probably haven't heard it before, so maybe it'll be of interest to some of you. But I did spend 33 years with the Bureau of Reclamation. Since that time, I've been in the water consulting business. And you can see I got 3 titles up there. Senior Consultant for HDR Engineering, Senior Associate with Water Strategies, Interim Executive Vice President, National Water Resources Association. Now I can tell you that I don't know what a consultant is, I don't know what an associate is, I don't know what an executive vice president is, and I'm not sure I know what interim means, but I do know what senior means. I'm waiting for emeritus, because when you get to be emeritus, you work less and get paid more. Anyway, it's a great pleasure to be here. I am just going to take a fairly simple approach. I'm not a lawyer. I'm really pretty just pragmatic person that had to deal with all of the issues that the Supreme Court established under the Supreme Court decision and decree. And so I'm just going to talk about my simple view of the authority that the Secretary had, and then the history of what occurred since 1964 when the decree was initially issued by the court. And I need to emphasize one thing too. When I say Secretary of the Interior, I'm using a very broad definition of Secretary of the Interior. I'm talking about the Secretary herself, I'm talking about the Assistant Secretary, I'm talking about the Commissioner, I'm talking about the Solicitor's Office, I'm talking about the Bureau of Reclamation, I'm talking about the guys at Hoover Dam that have their hands on the valves that are opening and closing. So I'm using a very broad definition of Secretary. The Secretary makes the important decisions, but there's a lot of things that go on the Colorado River that the Secretary never knows about. And but yet the Secretary's responsibility and role is invoked when that happens. So anyway, I thought, you know, it all really stems from the Boulder Canyon Act, and if I can just summarize very quickly, the Boulder Canyon Act, it authorized the Secretary to build Hoover Dam, and so the Secretary owns and operates the facilities, and I'm focusing here primarily on the lower Colorado River, not the whole basin. And then the thing that the real authority that I think the Supreme Court emphasized is the contracting authority under Section 5 of the Boulder Canyon Act. And the Secretary was empowered by the Congress to enter into these contracts consistent with the state allocation that the Congress told him to use. And then along comes the Supreme Court and makes their decision. And I don't know if the Supreme Court expanded the Secretary's role, but it sure sounds to me like the Supreme Court did. If you look at all the things that the Supreme Court told the Secretary that he had to do, measure and account for all the water. Under Section 5 of the decree, the Secretary has to put out an annual decree accounting report that shows who used how much and where and what state they were in, and showing that the entitlements were within the allocations that were provided. It made it clear that state law doesn't apply to the main stem of the Colorado River, except for the lower basin tributaries before they commingle with the main stem. Prior to that, it was unclear what state law was. We had contracts for Colorado River water that the state of Nevada actually entered into with some of its Nevada water users. And the Supreme Court said those weren't legit. Only contracts with the Secretary can be used to have a Colorado River entitlement. The Secretary, it enjoined the Secretary from delivering water outside of the allocations that were made in the Boulder Canyon Act. So the Secretary was enjoined. But then they went on to tell the Secretary, but you have the authority to determine when there's a normal, when there's a shortage, and when there's a surplus on the Colorado River system. And the Boulder Canyon Act didn't talk about any of those things. But they make sense. I mean, there's times when there's more water and, it's appropriate to make more water available. There's times when there's less water and to make less water available. The Supreme Court also gave the Secretary the authority to allow unused apportionments of one state in the lower basin by another state if one state's not using all of its entitlement. And that's separate from surplus or shortage. And then this may be a little stretch. I don't know that the Supreme Court talked about beneficial use, but it's been implied, I think, that the Secretary has authority to enforce beneficial use standards in the lower basin of the Colorado River. So what is the Secretary's approach to doing this? And first of all, I think the Secretary recognizes what an important resource the Colorado River is and how important it is to the economy and the habitat and the stability of the states and people that use the water supply. And that certainly puts the Secretary in a position of having to be very judicious in how he applies the authority that he has. I think the Secretary has to consider the changing economic and public values that occur over time, especially those that get reflected in acts of Congress, environmental values, Endangered Species Act, NEPA, and all those sorts of things come into play in the Secretary's management of the Colorado River system, and he has to take that into consideration. He's limited in how he manages the river by a framework, a legal framework that started 85 years ago and made allocations of water to states and to individuals that are permanent. So under the law and the contracts that the Secretary's entered into, all of those contracts are for permanent service. That's the word that the Boulder Canyon Act used. And so that's what the Secretary has to deal with when he's looking at all these new public values and economic needs in the region and has to work within that framework. Secretary obviously also has to consider the views of others, the basin states, Indian tribes, NGOs, water and power interests. Everybody has a big interest in the Colorado River, and they're more than willing to share with the Secretary what they think the Secretary ought to be doing. I'm sure Ann can attest to that. So let's talk about the history. I mean, I think you can see how the Secretary has done this by kind of walking through the history and looking at what historically has occurred. I kind of broke down the history into what I see as kind of logical periods. First one I covered was 1964 to 1985. And during this period, there was really plenty of water. I think it got talked about a little bit this morning, but Arizona still wasn't using all of its entitlement. Nevada wasn't using all of its entitlement. California was using 4.4 plus, and actually in the 80s, in the 70s and 80s, they were up to 5 to 5.2 million acre feet in California, and they were borrowing water that was unused from the other two lower basin states. And so there's plenty of water, and all during this period of time, managing the decree and serving as Watermaster was pretty easy. You just got water orders every year and you delivered them. And it was just kind of ministerial. It wasn't a problem at all. So I wish I would have been involved back then. That was before I got involved. But the other thing that the Secretary did during that period of time is he did start doing the decree accounting reports that lay out how much water is used by user and state. And that's something that got started right away. The other thing that the Secretary did back then, and it's kind of interesting that happened, the Glen Canyon Dam had just been completed. I think it was completed the same year that the decree was issued. And the Secretary was interested in having Glen Canyon Dam filled quickly. And so one way to fill it quickly is to get downstream uses reduced. And so the Secretary wrote a set of regulations called 43 Part 417 that lay out procedures for making water orders to the Secretary every year in the lower basin, provide the Secretary an opportunity to review those orders for reasonable and beneficial use, and then make approval of those orders, and then in turn, if the water user doesn't agree, all this is done by the regional director, ultimately have an administrative appeal process to the Secretary of the Interior. And it's interesting that was done back then, that they did so. I mean, we had to use the authority later on, but to me it was always just kind of interesting that the filling of Glen Canyon Dam was so important that they actually pressed on water users in the lower basin not to use as much water. So in general, this was a mundane period. There were things that were happening that weren't so mundane, but I'm talking about mundane as it relates to the Supreme Court decree. This was the period of time when the Mexican salinity issues arose with Welton Mohawk Irrigation District and the poor quality water that was being delivered to Mexico. Ultimately, Salinity Control Act of 1974, Yuma desalting plant, bypass flows, creation of the Cienega de Santa Clara. There was also some significant floods that occurred during this. The two highest years of record on the Colorado River were 1983 and 1984. And so there was a lot that was learned about flood control operations on the Colorado River during that period of time. 1985 to 1995, and this was the beginning. I mean, in 1985, we started to recognize that the decree was actually going to have to be enforced. We had this 20-year period of bliss, where everybody got all the water they wanted. And in 1985, the Central Arizona Project Canal was getting finished. The first deliveries of Central Arizona Project water were being made, and everybody started to realize that we were now going to have to cut California back at some point to its 4.4 million acre feet. And so that, and everybody recognized that that was going to be a difficult issue because Metropolitan Water District in Southern California is the low priority water user in the state of California. All the ag districts have the right to the first 3.85 million acre feet. Metropolitan only has a right to 550,000 acre feet. And they're using about 1.2 million acre feet. So all under the priority system, all the cut, when Arizona uses its full entitlement, is going to have to come out of the Met service area. Well, it just so happens that Met service area at the time was around 17 million people, and that water supply was a significant part of their water supply, and there's big concern about, how are you going to cut that much water out of an urban area with 17 million people and not have disastrous impacts? So there was a lot of concern about that. So the solution was we can just open up ag to urban water transfers, and Met can go and buy water from all of those ag districts. There's 3.85 million acre feet of water there. Let's go buy the water, and we'll have that water moved to urban use, and by reducing the ag use and moving it to urban, they'll get down to their 4.4. It was a great idea, and Met jumped on top of that, and they went and negotiated a deal, the first water transfer of Colorado River water between ag to urban. They negotiated a deal in 1988 for 106,000 acre feet of water, where Metropolitan would pay IID to conserve the water with payments and implementation of water conservation programs, and have that water then transferred to Metropolitan's use. But what happens is they get ready, they send the agreement to the Bureau, they're looking for the Secretary to endorse it, and Coachella Valley Water District files suit. And Coachella says, wait a minute, we've got an intervening priority. And they had a good case because the seven-party agreement doesn't have quantified entitlements for use of that irrigation water. It has priorities for the use of the irrigation water. And if you're a higher priority, you get to use all you want. And if you're the lower priority, like Coachella was, if everybody else uses it up before you, and exceeds that 3.85 million acre feet, you don't get that water. So Coachella's coming in and say, hey, look, if IID doesn't use all that water, it belongs to us. And you can't transfer that water to Met. And I think at that point, everybody realized that the seven-party agreement was not what we thought it was, that it was flawed. And we had this problem with intervening priorities and this idea of transferring water from irrigation use to M&I use in California, and enforcing the decree was going to be more difficult than we thought. Some of the other things that happened during this period of time was, the other thing that California did is they know they're going to get cut back, so what do? They come to the annual operating plan meeting and they say, we can solve this problem. All the Secretary's got to do is declare surplus. And you've got all the water in the reservoirs and you can just deliver it to us. Well, you got 6 other basin states that are sitting there saying, California's been the bad guy for 75 years on this river, and now they're coming in and saying, we can just give them more water, and they got to learn how to cut back. So that was not a well-received idea. All I can say is. The other states objected strongly. The other thing that happened during this period of time was Nevada's use started to escalate. You know, I think probably back in the 80s and early 90s, nobody thought that Nevada would get close to its full entitlement for a long, long period of time. But there was just explosive growth in Nevada, and we began to come to the realization that we had a real problem with Nevada as well, because they were an urban area that were growing. They had a very small entitlement. They had no irrigation with their Colorado River water. There were no opportunities for Nevada to do irrigation to M&I transfers. And so we recognize we've got another urban area here and yet their problem in the scheme of things is pretty small. I mean, 300,000 acre feet is 4% of the lower basin allocation, and a relatively, you know, you can double that and it's another 4%. When you look at all the use in the lower basin, it didn't seem that significant. But anyway, it was another issue that came up. Also during this period of time, in addition to understanding the priority problem, the intervening priority problem, in 1990, when Metropolitan signed their agreement with IID for the water conservation program, IID was using 2.5 million acre feet. In 1995, after all the conservation measures had been implemented to save 106,000 acre feet of water, IID was using 3 million acre feet. Where did the 100,000 acre feet go? So, and what IID will tell you is they will say, hey, look, we got the right to use all we want beneficially on our lands. And so, you know, our farmers, crop prices got good and our farmers could use more water, and they did, and they have that right to do that. And if we hadn't have implemented the 100,000 acre feet in conservation measures, we would have used 3.1 million acre feet. So, you know, their argument was the water's there. But nevertheless, it just was another realization that ag to urban transfers weren't going to work, because you had these elastic entitlements under the seven-party agreement. You had no basis to measure changes in use that could be transferred from one party to another. So anyway, towards the end of this period of time, and you know, all this kind of transpired over a 10-year period. It was a tumultuous time. I mean, there was a lot of going back and forth. We had a drought period from '88 through the early 1990s. California was in significant drought, and you know, it was there was a lot of contention going on. And so, towards the end of this period, the Secretary did two things, or three things. One, the Secretary, I think in concert with the other 6 basin states, said, California, you've got to develop a plan. You've got to figure out how to get down to your 4.4. We know that you can do that through the ag to urban transfer, and a part of doing that has to be a change to the seven-party agreement that allows some quantification of ag entitlements so water can move from irrigation to M&I. Second thing that the Secretary said is we need more interstate cooperation. We need to have opportunities for Nevada to interact with the other states to try to help solve some of their water problems. And in fact, the Secretary actually proposed interstate marketing guidelines in 1994, and we almost got our heads taken off by some of the states. It was a pretty controversial proposal, but I think that putting that out there is actually what drove some of the cooperation that led to the state's success in many cases. I think the Secretary was providing some leadership there. The third thing that the Secretary said, and the other thing we need, is we have this argument over surplus, and we need to know surplus guidelines and how surplus guidelines can work, because there really is, you know, you got to remember back then, we thought the average flow of the river was still 15 million acre feet. And the actual use of the river back then, upper and lower basin in Mexico, was around 14 million acre feet. So we knew it was over-allocated in the long term, but we thought in the short term, you know, we had an extra million acre feet that could be used. So we thought, hey, look, it may make some sense to have some surplus guidelines, and those surplus guidelines can be used to provide California with water while they implement all of their water transfers from ag to urban use. And so anyway, this is where we were at the end of '95. Between '95 and 2000, a number of things happened. We had a wet cycle, the reservoirs got full, and it gave us some relief. I mean, we didn't have this big argument over surplus every year because there was so much water we were spilling and everybody could take all that they wanted. We did negotiate a key terms for the quantification of the 7-party agreement that would allow ag to urban transfers occur. David Hayes, who was the Deputy Secretary of the Interior, led the effort. He did a great job of facilitating with all the California parties, and it was just amazing that that came down. That was a long-term, I mean, that was like a 2-year effort to do that. I mean, and I don't know how many midnight, 3, 4 o'clock in the morning meetings we had to try to get that down. Secretary Babbitt, I think, also provided a lot of leadership. He would go to the Colorado River water users and make some pretty strong statements about interstate water marketing, a lot of pretty strong statements about, I'm going to develop surplus guidelines, and I think some of that provided incentive for people to come together. So anyway, during this period of time, we got a quantification of the 7-party agreement. California did a good job of coming up with the California 4.4 plan on how they would reduce their use over time, and we got surplus guidelines implemented. All of that was contingent on the QSA being signed by the end of 2002. We had negotiated the agreement, but all we had left was to do the environmental compliance. So we said, we'll give you 2 years to get the environmental compliance done, and if you don't get it done in 2 years, then the surplus guidelines are suspended. So we thought we were really in good shape. We had a signing ceremony in January of 2001 in San Diego. Everybody was there, all the states, all the California water users, Secretary Babbitt, David Hayes, all the staff, and we had a podium with a big banner across it that said, "Peace on the River." And everybody there believed that. I'm not kidding you. Everybody there believed that we had a solution in place, and it was gonna, we were gonna move ahead, and everything was gonna be good. All right. Now I apologize for this slide. This is my technological incompetence here. I couldn't figure out how to get this slide to look like the others, but anyway, from this 2000-2003 period became very tumultuous. And is Bennett Raley still here? Bennett deserves a lot of credit for getting through this period of time. There was a lot of anguish there, and Gail Norton too. A lot of anguish in getting through this period of time. But we started the environmental compliance. We had a problem with the Salton Sea. If you conserve water in Imperial Irrigation District, you reduce flows into the Salton Sea. The Salton Sea is a terminal body of water. It's getting saltier and saltier. It has habitat for some endangered species, and the reduced flows into the Salton Sea is going to have some impact. It's going to cause, the Salton Sea is going to become hypersaline at some point in time. I mean, there's salt coming in, evaporation, it's just going to get saltier and saltier. But if you reduce the amount of water that's come down, you make it get salty a little faster. So we had to try to figure out how to mitigate for that and how to get Endangered Species Act compliance. We are also going to expose a lot of the seabed of the Salton Sea, and there were concerns about air quality issues. But the bottom line is, we got into a big fight over the Salton Sea and how it was going to be mitigated for and who was going to pay for it. And everybody was saying, the end of 2002 comes, and we don't have a QSA signed. And the surplus guidelines, which were, in a record of decision that you couldn't deviate from, said that we had to cut California's use immediately. So this soft landing that California was supposed to get with surplus was suspended, and in 2003 we actually cut California from 5.2 million acre feet to 4.4. We had it was quite an experience. There was big debate over Imperial Irrigation District and reasonable and beneficial use of water. We actually enforced a beneficial use decision, or tried to enforce a beneficial use decision against IID. I think we cut IID somewhere around 200,000 acre feet of water. And the rest came out of MET. MET took a big hit. IID took a hit. IID sued, said the Secretary doesn't have authority to enforce beneficial use. And not only that, the Secretary didn't follow his own guidelines on how to do it. And the court got a hold of that and said, you're right, the Secretary didn't follow his own guidelines, but the secretary does have authority to do it. So the court issued an injunction. We ended up cutting Coachella back by a couple 100,000 acre feet, which was a huge hit for Coachella. I mean, their total use is only like 300,000 acre feet at the time. So it was a really tough, difficult time. Anyway, we then picked up and pursued the IID litigation and began our own, following the process that we were supposed to follow. And then credit to Governor Gray Davis in California, who stepped in and said, you know, this is a California problem. We recognize that we have to solve it. And he and his State Water Resources Control Board, a guy by the name of Richard Katz, the Bob Hertzberg, who was the Speaker Emeritus, I guess he got a lot of money too, Speaker Emeritus of the California House, did a tremendous job of facilitating with all the California parties over the Salton Sea and how to resolve and how to get a plan to address the Salton Sea issues. Bottom line is the state of California stepped in and agreed to be the backstop for the Salton Sea. And they got a clear commitment from the entities over what their obligations were, and then limited them, and then the state kind of stood as the backstop to really ultimately, if there's a problem, to be responsible for the longer term problem. When that was done, the QSA could be signed, and this is like October. All this took about 10 months. In October, QSA was signed, surplus was reinstated, and we were back to bliss. Except the drought. So 2003 to 2007, the drought ends, and in 2004, the drought was so bad that we couldn't declare surplus, so we were still at the 4.4 million acre feet. So California, despite all our concerns, found a way to get down to 4.4, and California found a way to get down to 4.4 right away, which was not what everybody had in mind. Now this starts to bring in an issue outside of the decree. But the upper basin, we had, it was the reservoirs, Powell was getting drawn well down, and it became a wet year in the lower basin. The lower basin tributaries had a lot of high flows in them. And the upper basin was concerned about how low Lake Powell was getting, and they wanted to see some reduction in releases from Lake Powell to protect their storage in Lake Powell. And so they wrote a letter to the secretary saying that lower basin is having a wet year, there's lots of water in their tributaries, and you ought to use that water in the tributaries to make the deliveries to Mexico under the Mexican treaty. That is just a huge issue. I'm sure many of you understand that. Between the upper and the lower basin, it's really a compact issue. It's not a decree issue. But it was just a huge issue, and it was suddenly very tense. And one thing about the secretary is the secretary has her hand on the valve. So the secretary's got to decide when it comes to these sorts of things. Here's the upper basin saying to the secretary, turn back the valve. Here's the lower basin coming in. Madam Secretary, you can't do that. You don't have authority to do that. And so we were going back and forth. And in the middle of all this, the secretary writes a letter back to the states and said, look, I do have the authority to change the valve if I want to cut it back. But I think there's enough water in the river this year that I don't have to do that. So she made a decision that favored the lower basin by saying she wasn't going to cut back, but she made another decision that favored the upper basin by saying that she did have the authority to do it, and by golly, in the future, if she had to, she would. The other thing she said to the basin states in this letter, it was a pretty strong letter. It said, you guys better sit down and figure out how these two basins should operate under the compact. And oh, by the way, you ought to also figure out what the guidelines ought to be for operations during shortage, because we didn't have shortage guidelines. And she said, I'm going to move forward and start a process to create those guidelines and to do that. And if you guys can get together and collectively agree on how that ought to be done, then I'll listen. She can't say I will accept it because she's got a lot of process to go through, but she said I'll certainly consider recommendations or give heavy consideration to recommendations from the states. And so the states went away and they developed consensus, and you know, to their credit, But these were really difficult issues, and the fact that the states could come together. They came to agreement on the upper lower basin operations. They came to agreement on shortage guidelines. And more important than that, they came to agreement on interstate banking regulations that added to the banking regulations, which were groundwater banking regulations that were put in the lower basin back in 1999. These were actually, I think as it was described this morning, these banking guidelines come much closer to interstate marketing of water. It really creates incentives and ways for states to cooperate with one another in the lower basin to have water move back and forth. Bottom line is, Secretary took it all and went through the NEPA and the ESA process and issued a record of decision in December 2007. And we still haven't had a shortage. The drought's getting worse. They did the basin planning. They had the binational agreement with Mexico. So lots of good things are going on. None of these things are necessarily related to the decree, but there are some pretty big things that have happened in the last 5 years. So what is the Secretary's role? I think the Secretary's role is to provide some stability and leadership on the lower basin, to make decisions, to threaten to make decisions, and to facilitate. Bring the states together and, hey, look, we got to solve this problem. I think it's the Secretary's role to consult with the states and others. She has to understand where everybody's coming from, and that's part of developing consensus. She operates the facilities. She's got her hand on that valve. She develops the annual operating plan. She does a lot of ministerial duties, the decree accounting, and all those things that have to be done on the Colorado River. So that's the Secretary's role. I can't give the Secretary all the credit, because the Colorado River Basin states are absolutely amazing, and I would say that they provide their own brand of leadership. Each of those states has their own constituency with their own set of problems and issues among their own constituency, and they have to manage that while they're working with the other 6 states and trying to find consensus positions that they can come to with all the states. So I think it's just amazing the job that the states do, and you have to give them, I think, a lot of credit for being able to respond to the Secretary in such a positive way. A couple of observations. I think that the Colorado River has had some success in resolving some very difficult issues over the last several years that I don't think I've seen other river basins make the same kind of result. And I think a lot of that is due to the significant authority and responsibility that the Secretary of the Interior has to bring people together to try to develop solutions to problems that everybody can live with. I look at the Columbia River, and you have 100 dams. A bunch of them are federal, a bunch of them are privately owned. You got Corps, you got the Bureau, you got all kinds of dams, and you got 4 states, and there's no single authority that really has any ability to make decisions. And I think they just go on and on forever with their issues up there. And others, the one that you mentioned, the 2 rivers in, that is really a difficult set of issues. I did some work on that when I was back in DC, and they don't have relationships among one another to allow, they don't have anybody who can tell them that they need to find a problem. So anyway, I think the success on the Colorado River is a lot due to the Secretary and the authority and responsibility that she has. I also think that the management of the river is a collective effort. Enforcing the decree is not something that just the Secretary did, it's something that everybody did. Everybody jumping on California, there's a pressure there that's associated with that. The other states and all the other interests on the river, I think it all works together. And then the leadership that the states provide as well. The other point that I would make that I think is important, we always talk about having this old law that we can't live with and doesn't give us any flexibility. The truth of the matter is there's a lot of flexibility in the law of the river. The banking regulations that were put in place in 2007, 20 years earlier, everybody would have said that's illegal, you can't do that. All kinds of things that's happened on the river over the last several years are things that, back in the day, people didn't think you'd ever be able to do it because the law of the river wouldn't allow you to do it. But there's been a lot of hard work by a lot of people to figure out, there's mechanisms there within that. The river And the law of the river changes over time. It can be interpreted, it can be added to. There can be legislation, there can be secretarial decisions, guidelines, operating plans, those sorts of things that expand and add to the law of the river and provide the flexibility to manage the river under these new economic, social, and economic conditions that we have to manage it under. So anyway, that's my pitch. Secretary's doing a great job. Always has, always will. Thanks.
Thank you, Bob. Since 2009, Ann Castle has served as Assistant Secretary for Water and Science in the Interior Department. She's been active on a number of important initiatives, including heading up the Water Smart program that Buzz mentioned earlier. You've served a long time in this position, Ann, and we want you to serve longer. We also want you to be back here. And Ann is a graduate of this law school and served in our advisory council earlier, and we'll ask Brad to take her aside when she gets back and see if she'll sign up again. And Tom McCann is a graduate of Stanford Law School. He's Assistant General Manager for the Central Arizona Project. He's been at the CAP for almost 20 years now and has really had a vantage point on those issues as an observer and participant. And we'll look forward to your comments, Tom. Yeah, you want to go first?
Well, thank you, Charles, and thanks to Brad for inviting me to be here today. It's a double pleasure because I do get to come back to the law school that I graduated from, these many years ago, and I think I know well, and I'm really delighted to see about 3/4 of the people in this room. So it's nice to be home. And I'm the member of the panel that is part of the group that Bob referred to as the secretary. And so I'm going to give you kind of a different lens on the secretary's role and some observations on what I think have been key to positive developments, to success in managing the Colorado River over the past several decades. So I have 5 keys to success, successful moves forward in Colorado River management. First is that we have very engaged and knowledgeable stakeholders, and Bob and Buzz both referred to this. One of the reasons that we have good people who are effective at coming together around compromises is because many of these key decision makers have served in multiple roles on the river, whether that's been in private practice, representing water users, with the state governments, with the federal government, whether that's congressional or executive branch, in-house with some of the major water users. We have a lot of people who have seen the river from multiple perspectives. And as an example, I'll start with our favorite son, Ken Salazar, who started out in private practice as a water lawyer, went with the state of Colorado, director of the Natural Resources Department, Colorado Attorney General, U.S. Senate, Secretary of the Interior. Bruce Babbitt, governor of Arizona, and then Secretary of the Interior. Gail Norton, was with the Interior Solicitor's Office for a while, then back to Colorado as Attorney General, then Secretary. And the list goes on and on. Mike Connor in the Senate, now Commissioner of Reclamation. There are people in this room, Jane Harkins, Tom Bushatsky, different roles on the river, Jennifer Gimbel, Tanya Trujillo. There are a lot of people who have sat on the other side of the table from where they're sitting now. And so that experience gives you the perspective of the other side and the ability to think creatively about a compromise that will honor and respect the interests of the other side. Number 2, objective technical support from the Bureau of Reclamation. Reclamation has served as a trusted source of data, of models, and analysis on the Colorado River. It's played the role that Buzz referred to as the river coach. And that has been very apparent lately, where Reclamation has been involved in doing all the modeling around the 2007 interim guidelines that Bob referred to. And the epitome of that is sitting in the back row, Terry Fulp, who was the modeler and provided that trusted source of information that allowed the states to come together around the 2007 guidelines. More recently, in the Colorado River Basin study, Reclamation provided the modeling and the data that, from which the future supplies were forecast and the demands were estimated. It's huge to have people agree on the data because that avoids years and years of litigation and dispute. And so Reclamation can fill that role of the honest broker. Number 3, litigation. We hate it, but we sometimes need it. We frequently say on the Colorado River that we've avoided litigation. But what we really mean is that we haven't seen much interstate litigation recently. There's actually been a lot of litigation on the Colorado River, and Bob pointed to some of it as instigation that made the parties come together around a negotiated solution rather than waiting for a judge to decide, because that's risky and expensive. So there was litigation that led to the Arizona Water Settlements Act, litigation that led to the restructuring of the allocation of Central Arizona Project water. There are a couple different lawsuits that really instigated the multi-species conservation program on the lower river and allowed that to continue, confirmed the ability of the parties to agree on a conservation program. Bob referred to the case of Imperial Irrigation District versus Norton. That was the case that challenged Reclamation's allocation and findings about allocations and waste in the lower river. And ironically, that decision was against Reclamation. The Southern District of California said Reclamation hadn't followed its own regulations. But what that led to was Reclamation to go back and very, very carefully follow those regulations. And in the meantime, people were getting the hint that something needed to happen. And that's what ultimately was a catalyst for the quantification settlement agreement that did put caps on allocations, that solved some of the problems that Bob referred to in terms of having a sort of unquantified, very senior right on the lower river. So the point here is that, not that I'm recommending litigation, but litigation can serve as the motivator that brings parties to the table when they wouldn't otherwise come. I will give one caveat about the litigation that we've had being kind of positive and not destabilizing. There's currently a lawsuit that was actually filed in 2003 by the Navajo Nation, but has been stayed for almost a decade and recently revived. That lawsuit strikes fundamentally at the the CAP project, allocations at the 2007 guidelines, at the quantification settlement agreement. If that lawsuit were to be successful, that would be a very destabilizing influence on the river. So I think that litigation can lead to positive developments, but that case may be the exception that proves the rule. Number 4, party politics don't define the issues. Politics are pervasive, but the divisions in this river don't break down in traditional party lines. The divisions are upper basin versus lower basin, agriculture versus urban, tribes versus non-tribal users, states versus feds, US versus Mexico. That's where the controversies are. That's where the divisions are, and you can't predict those divisions through party politics. And that's a good thing. Many of the decisions that have been made on this river are kind of counterintuitive to what you would think of as normal party politics. So for example, the Democratic administrations are seen as pro-environmental, but it was during the Clinton administration that Secretary Babbitt took very narrow positions on the ESA and on the applicability of environmental laws across the border in Mexico. The Republican administration is seen as pro-agriculture, pro-water user, but it was Secretary Norton who took the very hardline position that Bob Johnson described in limiting California to 4.4 million acre feet and bringing up issues of waste by Imperial Irrigation District. And I'll give you a state example too. Utah politics are almost always seen as very anti-environmental, but the Central Utah Project, which is the project that develops Utah's allocation in the Colorado River, has the most stringent water conservation requirements and a statewide mitigation program that is maybe the most successful statewide program I've ever seen. So counterintuitive to traditional party politics. Politics and the parties have not played a key role on the river. And that, I think, has allowed compromises to go forward, has allowed progress to be made because politics don't get in the way. And the key decision makers on the river do everything they can to depoliticize these decisions and to keep the discussions out of high-level politics. And finally, the Secretary of the Interior does have a big stick and has used it to very good effect over the years. We've heard from Bob in particular that secretaries have used their political pressure to facilitate key agreements on the river. They've established timelines that they didn't back down from. They've been personally engaged when the parties needed a little pushing and shoving. Secretary Babbitt established the 2001 deadline for the interim surplus guidelines that Bob described and stuck with it, and didn't back away from it even though key parties hadn't signed, and what looked like was going to be a surplus turned into a shortage. Secretary Norton established a 2002 deadline for the QSA and stuck with it. Secretary Kempthorne established a 2007 guideline or deadline for the interim guidelines, and that's what made it happen. Same thing with Secretary Salazar and Minute 319 with Mexico. It had to get done in 2012. He personally engaged in the process and dealt with Ambassador Sarakan, and it happened, and it got signed before the Mexican government turned over. So the point with the Secretary's involvement is that no matter how well-intentioned the key players are in the states and the feds. And no matter how intensely they are working among themselves, sometimes they need that additional pressure of the secretary to really close the deal. And we've seen that happen in a number of cases. So having talked about those factors that were present in some of our successful efforts on the river, I wanted to talk about how we're positioned to deal with what we're facing in the future. Flexibility has been the key for a very long time. The law of the river is flexible. We are able to adjust it and add to it as we go along. And we've had to make it up as we've gone along in many cases, and I think that's what we'll be seeing more of in the future. The QSA made it up. It created caps and allocations in the lower river for some of the first priorities, and that's something that's not in the compact, it's not in the Boulder Canyon Project Act. That was the evolution of the law of the river. Another evolution has been working within the state priority systems to deal with endangered species listings, like the Upper Colorado and San Juan recovery programs. Those are also evolutions of the law of the river. The 2007 interim guidelines, Minute 319 with Mexico, again, new agreements that we're adding to the law of the river that give us certainty in times of shortage, that reduce the risk and increase reliability. So we've got all that going for us. But what we're facing now is a truly historic drought. The last 14 years, from 2000 to 2013, have been the driest 14 years in the historical record that goes back to the 1880s. And this 14-year period is among the very, very driest in the paleo record of 1,200 years that's reconstructed from tree rings. So we talk about normal volatility on the Colorado River. That's not what we've got here. We have a really historic drought. And we've got to have new thinking. We have to have new frameworks to be able to deal with that. The fact that we are where we are now, where we haven't really had to deal with shortage yet, is because, as was pointed out, we entered 2000 with our reservoirs brim full. They were full, and there's a lot of storage on the Colorado River, as you know, 4 or 5 times the average annual flow. We also got a reprieve in 2011 with a really big water year that reversed the downward trend. But we have this prolonged drought. We have climate change impacts. And there is this emerging consensus that both the states and Interior have to do more, and we have to do better, and we have to do it quickly to ensure reliability. So I think it's critical for all of us to keep that culture going, to keep the flexibility, to use that flexibility. Both Buzz and Bob mentioned relationships. I think relationships are critical. And that cuts across a large spectrum, not just the states and the feds, but NGOs and tribes and Mexico and agricultural interests and big urban users. All of those relationships are going to have to come into play in order to be able to put systems in place that are going to allow us to adjust and deal with this new reality. Buzz says that Congress should and could take a larger role. I'll just point out that Congress has not been all that effective at dealing with difficult problems. They're better when you bring them something that everyone agrees to, and I think that's what we're going to have to do now. They've done great when we brought them stuff like the Arizona Water Settlements Act, various Indian water rights settlements, and much farther back, an example in Colorado, the Blue River Decree. That was taken to Congress. Congress blessed it. So I think the role of the Secretary will continue to be critical on the river. She is the Watermaster in the lower basin. In addition to that, though, Interior, under the Secretary, has the key facilities all up and down the river. They're the biggest provider of storage. They really are the major water user on the river. So the Secretary and Interior have to be integrally involved in discussions about how we face this new future. We're going to have very carefully calibrated balancing of the risks between the upper basin and the lower basin, between agricultural and urban interests, between the tribes or among the tribes and other water users and Mexico, ecosystems, recreation, energy, all of those interests are going to have to be balanced. And I think it very likely that the pressure of the Secretary will be necessary in order to catalyze those kinds of agreements. The good news is that these efforts are underway. It's not like this is coming as news to anybody. The states and tribes and the feds and NGOs are engaged in a process partly instigated by the Reclamation Colorado River Basin study of looking at next steps. And it's with a sense of urgency because the hydrology has turned on us, and we all know that we need to do something pretty quickly. It's not going to be an easy process. Despite the fact that politics haven't defined these issues, the kinds of steps that will need to be taken in order to deal with the new reality are going to be politically difficult. And they're going to hit, in my opinion, every person in the 7 Colorado River Basin states. These are steps that could affect the daily lives of people who don't know much about water, who don't understand where it comes from, who have no idea about the complexities that we're talking about here. So I would say that it's up to us, it's up to the people in this room who understand water and who people listen to when you talk about water because you know something about it. It's our jobs to educate, and not just educate about our perspectives, but to help people understand what the complexities really are and what the interests are on the other side of the table. We all have, I think, the responsibility to dispel some myths. And I'm almost out of time, but since I'm focusing on 5 today, I'm going to give you 5 myths that I think we need to dispel. 1, there's no magic bullet that's going to solve this problem for us. It's going to take a whole range of incremental solutions. Number 2, and this is a corollary of number 1, municipal conservation is great. And we've done really well in this basin with municipal conservation, and we can do more, but it will not solve the whole problem. We can't use municipal conservation alone to get ourselves out of this shortage. Number 3, too much reliance on agricultural fallowing is destabilizing. It's destabilizing to local economies. It is risky to food security. It will be harmful to the overall economy in the Southwest, and it has an impact on the quality of life that we value here. So we can't rely entirely on agricultural fallowing either. Number 4, Mexico and tribal interests have to be part of the discussion. We have to make sure that our Native American partners and our sister country across the border, that their interests are honored as well. And number 5, environmental and recreation flows aren't just nice things to have. They're essential to the economy in the Southwest, and they have to be part of the balancing that goes on. So I have a request that you join me in dispelling those myths when you talk to people. I think it's really important. I think education is the way that we provide the platform that's going to be needed to enact the solutions to deal with our new reality. Thanks.
I'll just stay here in the interest of time. Let me start with a little bit of historical perspective because we've been talking about history a lot today, and particularly stemming from Arizona v. California, and a piece of it in particular that really has defined largely what CAP is about and what the state of Arizona has been about. And you heard about the Arizona Water Bank earlier today, and it's really a key part of that too. In the Special Master's report, he talked about what happens if there's a shortage. And what the Special Master recommended was proportionate sharing of the shortage among the states based on their entitlements. I think that sounded pretty good to Arizona. But when it got to the Supreme Court decree, the court said, back to, we've talked a little bit about how they were interpreting the act, said, well, that's not really in the Boulder Canyon Project Act. It doesn't say that that's the answer. That's probably something that's left to the Secretary's discretion. So that's where the decree came out, or the Supreme Court opinion, was that in time of shortage, it would be left to the Secretary to decide what would happen and how the water would be distributed. So that set up Arizona for what probably Professor Glennon was talking about, did we win or not? When you go back to Congress then to get the CAP authorized, which is why we went to the court in the first place with Arizona v. California, we ended up with something that's usually referred to as the junior priority. And as I said, that really has been a defining aspect of how CAP operates, the underground storage that we do through the Arizona Water Bank. A lot of our attitude with respect to the other states is all because to a certain extent we have that chip on our shoulder of being the junior priority user. Well, there were even some in Congress at the time that asked, why is Arizona going to agree to that? Why are you going to give up what you won, or a large part of what you won in the lawsuit? Why are you going to change that? And the answer, frankly, was because Arizona believed that it was getting augmentation. And if you look at the speeches that even folks like Brad's dad made at the time, he said, augmentation is going to happen and this priority business is going to be moot. And we believe that. And, why do we believe it? Well, you can look at the testimony of Governor Love from Colorado in 1965. He said all 7 Colorado River states are in complete agreement on the necessity of augmenting the natural water supplies of the river system. It is only in this manner that the future problem of the Colorado River can be alleviated. Unfortunately, the Basin Project Act didn't actually direct the Secretary or anybody else to undertake augmentation projects. It did, there was a lot of discussion in the context about what was out there, what the possibilities were, but what it specifically directed the Secretary to do was to prepare a report. And the report was issued in 1975. It was a West-wide study report on critical water problems facing the 11 western states from the Department of the Interior. And I just want to read one brief summary of the finding with respect to the Colorado River. It says the Colorado River will not yield enough water under normal circumstances to meet upper and lower basin demands, Mexican treaty obligations, and system losses. Thus, the basin faces future water shortages unless its natural flows are augmented or basin development is curtailed. That was 1975. You could also put that same quote into the basin study from 2012 and nothing's changed. So maybe we should talk about why nothing's changed in a sense. Get my notes back. There was progress after the 75 study came out. The study noted that the Bureau of Reclamation was engaged in some test work in the Imperial Valley on geothermal brine desalination. The Bureau also had a pilot program for weather modification in the basin. By 82, the Bureau had a program they called the Colorado River Enhanced Snowpack Test that was ready to go. It was a multi-year, multi-million-dollar project to kind of demonstrate the feasibility and the success of weather modification. But as Bob noted, well, what happened in 83 and 84, the 2 wettest years on record. So this is where we get to what Professor Glennon sometimes describes as the hydrological cycle. You know, we got all this water. We don't need to be augmenting anything. What are you talking about? And all that sort of gets forgotten and goes off into the recesses of libraries and history. And we moved forward then to, you know, through the 90s. There was plenty of water through the 90s. And then now we're back into a situation where, oh, we're in shortage now. We're not shortage yet, but we're in a drought and we're looking toward shortage. So you come to the Basin study in 2012, and it's got 4 portfolios of solutions. Every one of those portfolios has augmentation options as a key component. But things have changed. I would almost suggest there's been a climate change in Washington, D.C. since the 60s, when augmentation was talked about in the Basin Project Act. You had NEPA in 1969, the Clean Water Act 1972, ESA in 1973. Both Buzz and Bob had talked about the federal government's difficulty in speaking with one voice and all the different hats that the Secretary has to wear. You got the Bureau of Reclamation, the Bureau of Land Management, Bureau of Indian Affairs, Fish and Wildlife Service, National Park Service, and others as well. And all of those have different views on how things ought to be done. So how is it then that we move forward and try to solve the problems of the basin? And I think that, I think you reiterated, Ian, based on what Buzz had said, that the Secretary's role in many respects is that river coach right now. I mean, because frankly, I see it as difficult for the Secretary to suggest any particular augmentation alternative or any other, you're going to do this, the states need to do this. It's going to come from the states and the water users at this point. It comes with help when there's threats made, or when, like Secretary Norton said, you guys come up with an agreement on operating the reservoirs, or I will, and that's what happened. The states got together and they reached agreement, and then the kind of the flip side of that then is the states say, all right, we've done this, we've reached agreement. Secretary, we really expect you to implement this agreement and adopt this agreement as your decision. And for the most part, you know, that's been what's happened. Another example along those lines, Bob, you talked about the off-stream storage regs in 1999. Well, starting in 1992, CAP, Metropolitan Water District, and Southern Nevada had a demonstration program for interstate banking before there were any rules. And we stored, well, 80-something thousand acre feet for MWD in central Arizona. And then we kind of came back and said, okay, we've done this, now let's figure out how to make it a reality, make the water available back to those that stored it. So what I see is again, that the federal government and the Secretary has an important role in all this. I mean, the Secretary is the Watermaster. That's not going to change. The Secretary does control the releases from the reservoirs. But the impetus, the driving force for the new thinking and new frameworks that you talked about, Ian, I see those as coming from the states getting together and making the hard decisions, the compromises among ourselves, trying to reach that consensus that we can then present to the Secretary and say, all right, you know, you've cajoled us, you've threatened us, you've told us we need to do this. We have now, and here it is, and we hope that you'll adopt it and help us move into that new regime. Because we do, as I think Jim Lockhead was talking about this morning, we do have changes we need to make in the basin, in our water use patterns, our basically a lot of the things that we do in the basin. We need to move toward a point where we are sustainable over the long term, and I think that we can do that. I think we will be able to reach those agreements among ourselves, among the states and the water users, and hopefully the federal government will be a partner in that and not an obstacle. I'll stop with that.
My instinct is that it really has gotten late and maybe we need to pass on questions. Is that right, or does that seem right? I do want to say that I can't think of a time when, because you always want to have the discussion at the end, but boy, this was so terrific, wasn't it? I mean, just absolutely unbelievable. So there's a reception next door, and thank you for